Hey everyone, how you going? Hey Ali.
Hi Rob, how are you? Hi
Yeah, good,
everyone,
thank
thanks for joining our webinar today, 5 Essential Contracts for Your Online Business. Let's begin. I'm Alexandra Perry. I am a practice leader in our corporate and commercial team, and I'm joined today by my colleague Robert Ney. Hi Rob, how are you?
Yeah, good, thanks. Thanks for joining everyone.
Let's get into it. But before we begin, I just want to run through some housekeeping with you all. You will be emailed a copy of this webinar after the recording is finalized, and we will be answering questions at the end. So please feel free to submit your questions in the chat box during the webinar, and we'll get to as many as we can at the end. There will also be a survey sent to you or a screen pop up after the webinar, and we would be really grateful if you could complete that. So today we will look at confidentiality agreements, business terms and conditions, other third-party agreements, privacy policies and website terms of use, employment and contractor agreements, and as I mentioned, we'll have a Q&A at the end. Please stick around because there is a special offer, and we will also talk about our masterclass offering that we have next month. Confidentiality agreements. Rob, what are they?
Yep, they're pretty well as they sound, Ali. So they're a legally binding agreement that covers the sharing of confidential or sensitive information between two or more parties. So it's a really important document, particularly if you're just starting out your new online business. You might not necessarily have all of your commercial terms sorted out. You might not, if you're running an app, you might not really know how the app is going to work at that stage. Or, if you're supplying goods, you might not exactly know what the specifications for those goods are at that stage. But you also might need to start contacting third parties. So going to potential investors or manufacturers or other third parties that you're intending to rely on to be able to provide your goods or services. So given this, and given you might not have the arrangement sorted, it's really important that when you're sharing your business idea or your concept to third parties, that you have this agreement in place so that when they're receiving your confidential information, they're going to keep that secret and they're not going to share it to third parties because obviously that would be damaging to your business.
Cool, thanks. So you might have heard the mention of mutual confidentiality agreements or one-way confidentiality agreements. Essentially, the difference is in a mutual agreement, you have both parties sharing confidential information with each other, whereas in a one-way confidentiality agreement, you just have one party sharing information to the other party. You can also have multilateral confidentiality agreements where you have multiple parties sharing confidential information with each other.
Awesome, thanks, Ali. So when we're talking about a confidentiality agreement or an NDA, what are the key clauses? I know they're pretty stock standard, but I think there are sort of some areas where they're a little bit more bespoke.
Yeah, totally. They're quite a pro forma agreement, and you can find templates online. There are a number of them. However, the key clauses that you would want to see or you would want to bespoke for your certain arrangement would be your definition of confidential information. So again, that can be reasonably standard, but if you have specific confidential information you want to call out in your agreement to make sure that that's protected, then it's worth doing that. The other definition is purpose. So the purpose of why you're exchanging confidential information with the other party. Generally, if you're the discloser of information, you want to make sure that purpose is narrow so that the other party, the recipient, is only able to use confidential information for a narrow purpose, whether it's a certain commercial arrangement or to discuss entering into a joint venture or partnership or to develop technology together. Term is also a term that can change depending on the agreement and the arrangement at play. Often your term, you might see a 2-year or a 5-year term, but sometimes the confidentiality obligations actually they survive termination or expiry of the agreement. And that will be the case if you have confidential information such as maybe trade secrets that you want to keep confidential for as long as possible. So it might be that the confidentiality obligation, it survives until the confidential information is in the public domain. In a one-way confidentiality agreement, you would also think about including an indemnity where if you were disclosing that information to a third party, you would want that party to cover you for any loss or damage that you suffer as a result of their breach of your confidentiality or their confidentiality obligations under the agreement.
Yeah, cool.
Let's turn to...
Just Ali, when we're talking about indemnities, I think it's worth just touching on, an indemnity is quite a key clause in a contract. So, it's an obligation to compensate. So just, I guess, flagging if you've got a confidentiality agreement that you're receiving from a third party, it's always worthwhile flagging any indemnities that you're required to give and running them by a lawyer to check.
Yeah, totally. It's a really good point, Rob. And it's something to keep in mind if you've got a mutual confidentiality agreement as well, and there's a mutual indemnity, it's still worth considering your specific obligations under that indemnity. Let's move on to business terms and conditions. What are they and when do you need them, Rob?
Yeah, thanks, Ali. It's a broad catch-all that we've sort of listed here in terms of calling them business terms and conditions. So this document is your customer-facing set of terms. So it will ultimately depend on what you're actually providing. Some examples, for instance, would be if you're an IT business, or if you're offering a platform or an app, you might have a SaaS agreement in place or app T's and C's. Otherwise, if you are supplying goods, so apparel, for example, you might call it a client agreement or a supply agreement, that kind of thing. So it does differ. There's a whole heap of things that you can call it, but essentially the thing to take home is that it's a set of terms that's between you as your business and then your customers who are purchasing your goods or services.
Are there specific clauses that you generally see?
Yeah, definitely. So as I sort of mentioned, first off, when you're starting your business, you might just have your confidentiality agreement in place. And then when you're ready to actually start servicing clients, that's when you look to get your business T's and C's in place. So one of the clauses would obviously be confidentiality. So typically the way that would work then is if you've already got a non-disclosure agreement or a confidentiality agreement in place with a customer, for example, then the confidentiality provisions in any subsequent agreement, which could be your business T's and C's, would effectively supersede the confidentiality agreement. Some other things there that we've got listed on the slide are goods and services, or goods and or services. So it might sound obvious, but it is really important that where you're supplying goods and services, you're clearly defining exactly what you're providing. And the sort of takeaway point here is that given that you're the party supplying, ideally you want to try to define the goods and services as narrowly as possible to make sure that there's a lower risk of your customer expecting more than what you're expecting to provide them. Some other things there we've got payment terms. So this is obviously critical, having a think about whether you want to take some payment upfront in the form of a deposit. That might be necessary where you're engaging third parties because you might actually have to pay amounts to them. And I guess on that point, ideally you would be taking money from your customers before you have to pay any of your third parties. The third point there we've got is delivery. So if you're supplying goods, title and risk, title refers to ownership of the goods. Typically what would happen where you're supplying goods is that ownership of the goods would only pass to your customer once they've actually paid you in full. And then risk refers to who bears the risk of loss or damage to your goods. Again, the standard sort of position is that once the goods have been delivered to your customers or, left at their premises, then the customer would be responsible for loss or damage. It's also important to think about any warranties that you're going to be offering to your customers. For example, if there's any defects or errors or omissions in the goods and services, whether you're going to be warranting to your customers that you'll fix those errors or you'll remedy any defects. And that will sort of tie into your consumer law obligations, which Ali will touch on in just a moment. And the last thing I'll get to before we touch on the Australian consumer law, which is really important, is liability provisions. So as far as possible, you want to try to limit your liability as a company as far as possible. So things to consider would be excluding consequential loss. Consequential loss includes things like lost profit, lost revenue, loss of data. So ideally, you want to be excluding any liability at all that you have for those types of losses. And then importantly, one of the other sort of big ticket items in your business T's and C's would be having a cap or a limitation on your liability. So Ali, do you want to just quickly touch on the ACL?
Yeah, thanks, Rob. As you said, it's really important. So the Australian Consumer Law, or the ACL, is a law that protects consumers and small businesses. Under the ACL, when a consumer buys your goods or services, those goods and services come with automatic guarantees. Now, these guarantees exist regardless of any other warranty or guarantee that you provide in your agreement to your consumers. And you, as the business, are not allowed to contract out of these automatic guarantees. So when you're drafting or you're preparing your business terms and conditions, it's really careful. You need to be really careful that nothing in that agreement either seeks to limit or exclude your liability under the Australian consumer law.
Great.
Otherwise, this could amount to misleading, deceptive conduct, or even be deemed an unfair contract term, which is also quite a hot topic at the moment. So the Australian consumer law also protects consumers, including small businesses, who enter into standard form contracts that have unfair contract terms in them. Terms that are unfair would include terms that unilaterally seek to limit or limit a party's liability but not the others, or a term that might allow one party to terminate but not the other, or a term that penalises a party for breaching or terminating the contract but not the other. The reason it's such a hot topic at the moment is because currently, if the court finds that a term is unfair, the term will just be deemed void and unenforceable. But there is a draft bill before Parliament at the moment which looks to expand the unfair contract terms regime by adding new prohibitions which will attract significant penalties. So under the proposed legislation, you could be penalised for entering into an agreement with unfair contract terms if it's your agreement that you've provided to a consumer. And you could also be penalised if you seek to rely on those unfair contract terms. And the penalties are significant. We're talking the greater of $10 million or 10% of your annual turnover for the previous 12 months.
Yeah, that's really, really good point there, Ali. And I guess sort of an example, going back to what I was mentioning about consequential loss, is if, for example, in your business terms and conditions, you say you as the supplier is not going to be liable for consequential loss, it would likely be unfair to have that operating only in your favor. So you would want to make sure that that applied mutually, so your customers would also not be liable for consequential loss.
That's a good point.
Think the last thing just to mention in terms of business terms and conditions, and something you're probably familiar with though, is there's a number of different ways that your business T's and C's can look. So there could be a click wrap agreement, which is where your customers are looking at your terms online, and then they're scrolling through and clicking or ticking a box and saying that they accept those T's and C's. Otherwise, they could be a hard copy document. They could be a set of terms with an ability to electronically sign through DocuSign or another platform like that. Great.
Cool.
Should we move on to privacy?
Sure. Or do you want to talk about third-party agreements first, Rob?
Yeah,
Maybe
perfect.
mention what kind of agreements our viewers might want to have with third parties.
Yeah, perfect. So we've touched on it a little bit, but when you're starting your business, you'll likely be relying on other parties. So some examples we've got is if you are once again selling clothing or goods or face masks or anything like that, you'll likely have a manufacturer who you want to engage. And it's quite important to think about finding that manufacturer, but also getting them signed up to an agreement. And the reason for that is that there's going to be a correlation between that agreement with the third party and then your customer T's and C's. So as I touched on earlier, if you're required to pay your manufacturer under a manufacturing agreement, ideally you would want to align the payment terms so that you only have to pay amounts once you've actually been paid by your customers, because that'll sort of mitigate your cost exposure as a business. Some other examples are, so from an IT perspective, if you're running an app or a platform, you might be relying on third-party software providers. So you could have Google Maps integrated into your app, which means that you would likely be signing a software license agreement. Now, when you're contracting with big third parties like Google, it's likely that you wouldn't really be able to negotiate that agreement, but it's just important to note that you might have to sign onto it, and it's a good idea to be well versed on what your obligations are under that agreement. And then we'll touch on this a little bit later in one of our last segments, but contractor agreements as well. So if you're looking to bring on web designers, app developers, artists, anyone like that, you might need a contractor agreement to cover the services that they're providing for you.
Cool. Let's move on to privacy now. So a privacy policy sets out how your business collects and handles personal information. You need a privacy policy if you are an APP entity, which is a term defined under the Privacy Act. And it's essentially an agency or organization that has a turnover of $3 million or more. So if you don't have an annual turnover of $3 million, then you may not be deemed to be an APP entity, and therefore you aren't required to have a privacy policy. However, there are some exceptions to the small business exception. So even if you have an annual turnover of less than $3 million, but you provide a health service and collect health information, then you will still be deemed an APP entity, and you'll need to comply with the APPs and have a privacy policy. Even if you're not an APP entity, though, we generally recommend having one in place as best practice, because it sets you up for success going forward, especially if your business is going to grow.
Great, thanks, Ali. What do you usually see in a privacy policy?
So the APPs actually specify what needs to be in a privacy policy, and it needs to include things like the details of the entity that's collecting the personal information and their contact details. You also need to have set out what information you collect, whether it's personal information or sensitive information, which would be things like health information or sexual orientation, religious beliefs, that kind of thing. And that just attracts a slightly higher threshold of care. Also, why you're collecting the information and what you will do with the information, where it's stored, and how you will or who you will disclose that information to. So whether there are any specific third parties that you'll be disclosing the information to. It should also set out whether or not you are going to disclose the information overseas, so outside of Australia. And there are some further obligations around cross-border disclosure that are good to know if you do transfer information outside of Australia. And it's also important to include provisions around how an individual can access or seek correction of their information, and how they can make a complaint, and also how you as the business will handle any complaint that's made in relation to privacy. The next slide is on website terms of use. Rob, are they legally required or are they more of a nice to have?
Yeah, definitely a nice to have, Ali. So website terms of use, again, all of these agreements sort of explain what they are in their names, but they govern visitors to your website, the terms on which they can access your website, use and interact with your website. So the key sort of difference between this and then your business terms and conditions is that this will apply to literally anyone who clicks on your website, as opposed to your business T's and C's which would just apply to people who are actually purchasing your goods and services. So as I mentioned, it governs the use of your website. If there's the ability to post comments or content or anything like that on your website, then this set of terms would cover, who owns that content, what they can and can't do in terms of uploading content. So, some restrictions in terms of them uploading inappropriate content or that kind of thing, or, posting comments that are bullying or harassing or defamatory. Now, whether they're legally binding is a good question. That's because ultimately the way they usually operate in terms of acceptance is that the person visiting your website is deemed to have accepted the website terms of use from just viewing your website. So they may not have actually had an opportunity to see the terms and conditions. So they're definitely a nice to have. I think if you've got a website which allows for interaction, it's a good idea to have these website terms of use, but they're not a critical document.
Cool. Thanks, Rob. And then let's move on to contractor and employment agreements. Sometimes they can be viewed as the same thing, but what's the difference?
Yep, very good question. And I'll sort of get to why that's important in a little bit. So this is where you're looking to bring on personnel to help you run your business. So the first one, employment agreements. An employment agreement is an agreement between an employer and an employee, and it's a contract for service. Now, why this is important is because employment agreements are covered by the Fair Work Act, which is the legislation in Australia governing employees and their relationships with employers. Whereas a contractor agreement is just a commercial contract between a business and then a contractor, an independent contractor. So they could be a sole trader, or they could be an individual, or they could be just another company. Now, as I mentioned, the Fair Work Act covers employment agreements, but it doesn't cover contractor agreements. And when we're talking about employees under the Fair Work Act, they've got a number of entitlements that need to be covered in the employment agreement. So we're talking about, leave, annual or personal leave, or whether there's any applicable awards at which the employee needs to be paid, and also, their salary. So when we're talking about a contractor though, typically the way that would work is that the contractor would be responsible for paying their own super, as opposed to an employer paying an employee super, and also organising their own taxation.
So I guess on that basis, it can probably be tempting to engage all people that are working for you or your business as contractors as opposed to employees, given you wouldn't be responsible for superannuation or taxation. But that's not always advisable, right?
Yeah, it's a really good point, Ali. So we often see that with our clients, particularly, if they're just starting out their business. Bringing on an employee is actually quite a big step because, as I said, you have all of these legal obligations that you owe to any employees that you bring on. So it's definitely tempting for businesses to just try to contract out all of their services. And, that might be fine, but it becomes a little bit problematic because of a thing that we call sham contracting. So sham contracting is a practice where a company or a business brings on someone as a contractor under a contractor agreement, but when you look at sort of the whole relationship between the parties, that person should actually be considered an employee. So if you've got a contractor who's working for you full-time, is using your equipment or wearing your attire, that kind of thing, chances are that the ATO who monitors this practice would look at that and say, actually, this person is an employee. So I guess sort of importantly, one of the things that you can do when you're looking to bring on people is to have a look at the ATO website, because there's a good tool on the website whereby you can just input information about your business, about the person you're looking to bring on, and it'll spit out an answer, or it might not give you a definitive answer, in which case, you might want to get an employment lawyer to give you some advice there. A good sort of example, and something that has been in the news quite recently, was Uber and companies like Uber, where they essentially have a whole heap of contractors being their riders and their drivers. And there was a question as to whether those riders or drivers were contractors or employees. Now, I believe that actually settled before we reached a landing on it, but it is a really important topic at the moment in this sort of gig world that we're living in.
And it's a good reminder to get advice if you're unsure.
Yeah, definitely.
So an employment agreement, the clauses you would generally see in an agreement like that would be your working hours, duties, roles and responsibilities, also whether the role is casual or full-time, what the salary, additional benefits, any bonus schemes, as well as notice period and termination provisions and leave entitlements. Now, Rob, as you mentioned before, a lot of those provisions or those entitlements are prescribed under the Fair Work Act. So there's not so much room for movement as there might be in a contractor agreement. So on that, what kind of clauses would you see in a contractor agreement?
Yeah, definitely. It's essentially, as I said, it's a commercial contract. So in a similar vein to your business terms and conditions, you'll see some of the same clauses here. So a description of the services or the goods and services and the payment terms. Now, if you remember when we were talking about your business T's and C's, when we were talking about defining the goods and services, we said that you want to define them as narrowly as possible. If you're bringing on a contractor, it's sort of the flip. So you want to try to define that as broadly as possible, so that if you, for instance, missed things in the scope of services, then you can actually just require the contractor to carry out those additional or incidental services without having to pay them anymore. Some other things, and one that's really important and we haven't really touched on as yet, Ali, is intellectual property. Now, this is important when you're bringing someone on to help you get your business up and running, because if they're an app developer and they're actually developing intellectual property or improving your pre-existing intellectual property, ideally you would want to own all of that IP, so that then you can commercialize and use and potentially sub-license that IP at a later stage. The last one we've got there on the screen, Ali, is restraint of trades, or sometimes they're known as non-compete or non-solicitation clauses. Do you want to just sort of run through what they are?
Yeah, sure. It's generally used to prevent or limit your contractors from providing their services to your competitors, either during the term and sometimes for a reasonable period afterwards. The non-solicitation is more about ensuring that the contractors don't solicit any clients or employees away from you. Now, the restraint can have both a time period, so a period after the agreement or their engagement with you ceases, as well as a geographic area, and both the restraint period and the geographic area to which the restraint applies needs to be reasonable, and needs to be for a purpose that's necessary to protect your business interests, because if it's not, it won't be enforceable. So this is a clause we always recommend that you seek legal advice on before drafting.
Great, thanks, Ali. Okay, cool. We're up to the Q&A section of the webinar, and we've had a number of questions come in when people signed up to the webinar, which is excellent. So we've got some of those, and we've also had quite a number submitted. Just a reminder, if you've got any others, feel free to send them through now using the chat box, and we'll get to as many of them as possible. Ali, can you see any there that you want to have a crack at first?
Yeah, one that came through earlier was whether or which situations it is best to limit damages to direct loss only, as opposed to including indirect losses, and especially for confidentiality agreements. It's fairly market standard to exclude indirect loss for both parties, and that's even in a confidentiality agreement. Of course, if you are disclosing information and the other party is receiving and not disclosing information to you, and there's an indemnity in your confidentiality agreement, then if you can include indirect loss, so where the other party would cover you for any indirect loss that you would suffer as a result of their breach of their confidentiality obligations, then I mean, that would be great. However, as I said, it's market standard to exclude those.
Great, thanks,
Rob,
Ali. Yeah.
There's one here I think that might be good for you, in relation to how you protect ideas when you're working with freelance workers or programmers.
Yeah, excellent. So it goes sort of back to the point that I was mentioning before, particularly with respect to IP. So where you're looking to engage a freelancer or a web developer or anyone else, you would typically engage them under a contractor agreement, obviously unless they're an employee. And then in that contractor agreement, you would have IP provisions. Now, what those IP provisions would include would be who owns any intellectual property in any deliverables that they're providing to you. So what we usually call that new intellectual property. And then the way it sort of standardly works in those types of agreements is that each party will own any of their pre-existing IP. So that's IP that they've developed before the agreement or independently of the agreement. So, you know, for another party. But then if anything is created as a result of the services that they're providing for your business, that's what we would call new IP. And ideally, you would want to be owning that IP. Some other things to consider is, I guess, confidentiality once again. So making sure that the freelancer is keeping the agreement itself and their correspondence with you confidential.
Yeah, cool. And I suppose that would bring us on to a potentially another type of agreement, which would be an IP assignment agreement, if in the event that IP was created under an engagement, a contractor engagement, and it wasn't clear where the ownership of that IP sat, you might end up needing to have the contractor assign all of the IP for the avoidance of doubt to you as the business. There's another one here about whether NDAs written in Australia for an Australian company can be applicable overseas. So yes, in short, it will be important to understand a few things. So if you are providing mostly performing your business services in Australia, then you will want your agreement to be, your confidentiality agreement to be governed by Australian law, and that will be set out in your confidentiality agreement, in which case the overseas party that's entering into that agreement with you is agreeing to be bound by the confidentiality agreement under Australian law. Now, if there's a breach of that agreement, then most likely any court case or claim would be brought in Australia, in which case you would need the other party would need to appear in Australia to counter those claims.
Yeah, great. We've got a whole heap of questions so I'm just trying to look through and see if I can sort of group a number of these. There's one about the GDPR and privacy. Yeah, so that's something that is quite a big topic, and we can't really go into too much depth here. But I guess all we should say there is that the GDPR is the privacy laws that apply in the European Union. So that's, I guess, relevant, Ali, where you're marketing your goods and services, actively marketing in the EU. And I'm thinking that sort of the important considerations there is that if you've got a privacy policy, there's likely some things that would need to be tweaked to allow it to be GDPR compliant. But as I understand it, the GDPR is a lot more rigorous than our privacy laws here. So it's probably something that you want to consider getting some specific GDPR advice on.
Yeah, definitely.
Great, we've got a little bit more time, Ali. So if there's any that you see there. There's one that I can see here. So it's when a small business is being contracted by a university, what would be important flags other than usual B2B agreements? Really good question. And I think this is almost a bit of a commercial question. So when you're dealing with government entities, and I guess just bigger entities, in the private sector as well, as a small business, your ability to negotiate that agreement is probably going to be quite limited unless, the services or goods you provide are one of a kind, in which case, the uni really wants to engage you. Some things to think about there is making sure that you've got your liability provisions included in the agreement. So when you're receiving an agreement from a third party, chances are the agreement will be silent in terms of a cap on your liability, consequential loss, proportionate liability, those concepts which help to limit your exposure under the agreement. Some other things to consider is there might be specific laws that the government entity or the university actually needs to comply with themselves, and they might want to, or they might need to pass on that compliance to you as well.
Thanks, Rob. There's I guess a follow-up question to something I said earlier, so I will respond to that. It's whether an IP clause which states that ownership of new IP transfers on full payment is sufficient, or whether you need to include a provision for IP assignment for any new or future IP. My preference is that having a statement that says ownership of new IP transfers on full payment is good. However, it's always nice to have something else in there to say that the other party will do all things necessary, including sign any IP assignments or assignment agreements or enter into further agreements in order to make that assignment effective. So I guess it's more about ensuring that the assignment is actually effective and whether or not that would be deemed to be effective. There's a raft of case law on that kind of stuff, which we don't have time to delve into today.
In our 1 minute left, maybe not.
Yeah.
I've got one, I think we've got time for one more. So there's a question, a development studio wants me to produce all plans before they sign an agreement. Yeah, a little bit of a red flag here. So, as lawyers, we're quite risk averse. It's always important to have an agreement in place with any companies or businesses that you're engaging with. The main reason for that is quite obvious. If, for example, you deliver your plans to the development studio and then they go and take them and use them and they don't pay you, it's going to be hard without a contract in place to be able to enforce their obligations to make payment. And also just in terms of who actually owns those plans, any IP in those plans, and confidentiality, and also the terms on which they can use those plans. So are they able to provide them to third parties. Are third parties able to rely on those plans? I think that's pretty well it. Looking at the time, Ali, unless there's any other ones that you can see that you want to quickly answer.
I guess we've got time for maybe one more quick one. There's a question about whether there are requirements for small businesses to store customer data on Australian servers. The short answer is no, but you have obligations that you need to meet if you are either disclosing your information overseas or using it overseas. So you just need to be mindful of those obligations, and always worth getting some privacy advice on that.
Cool.
So that's probably all we have time for today. But before you go, as I mentioned at the start, I want to tell you about a special offer that we have. So it's to do with our membership service, which is LVConnect Pro. It's an all-you-can-eat buffet of legal services, in short. So we provide unlimited document drafting and reviews, unlimited legal advice consultations, HR and employment support, Australia and New Zealand trademark applications, company and corporations, and trust setup. So if you, anyone who's watched this webinar today is eligible to receive a complimentary consultation to discuss our membership offering and how it could help your online business with its essential contracts. And if you sign up for a consultation today, you will be able to redeem a special offer when you sign up to our membership. To book a strategy session, it's very easy. Click yes in the survey that will appear after the webinar and leave your contact information. Or alternatively, you can email reply@legalvision.com.au and mention that you watched this webinar. We also have a masterclass coming up next month. So you can learn from our experienced lawyers in an interactive virtual classroom environment. Limited spaces available, so being quick. And to qualify for this, you just need to visit the link in the post-webinar survey.
Excellent, thanks, Ali. And I think on that masterclass, we'll be able to drill down a little bit deeper with a small group of attendees. So yeah, as Ali said, there's limited spaces, so get in quick, and it'll be quite interactive. So we'll be able to talk to you about your business and dive a little bit deeper into some of the concepts that we've mentioned today. So that brings us to the end of our webinar. Thanks for joining me, Ali. It's been great chatting, and thanks so much for everyone. Thanks so much for everyone who's attended. I hope you got something out of it. Feel free to do the survey now, and then hopefully see a number of you at the masterclass shortly. Thanks so much.
Yeah. Thanks, everyone. Bye.